Welcome to the Emet lecture for 2013. We're in for a treat, although not as much a treat as I initially thought, because I read the title quickly, and as someone who teaches legal process, administrative law, I of course read it as process as punishment, and then I had to go back, which was a talk you could certainly give, and maybe ought to be given, but that won't be today's talk.
I'm sorry to let you down. Very sorry.
No, it's going to be exactly what everyone here would most hope: engaging, compelling, and especially for those who are here from McMaster, who are here as part of the philosophy department, the legal philosophy partnership. There's lots of great collaborative and interdisciplinary energy in the air, and again, I think we have the perfect speaker to do justice to those perspectives. And really my only role is dean, and I'm Lauren Sawson, the dean here for those I haven't met. Normally it's a face of familiar suspects, and happily I'm looking out on people I haven't had a chance to introduce myself to. But the point is really just to celebrate this lecture series. It's one of our most anticipated and has been revitalized through the collaboration with the Nathanson Center, and it's great to have our faculty lead, Professor Francois Tanguay-Renaud, here to do the actual introduction of Professor Duff in a moment. So, or Emet, for those who are not waking up thinking in Hebrew, is the Hebrew for light of truth, and I think if you look at the engagement with religion, ethics, culture, legal perspectives that are in their broadest sense connected to those ideals, you'll see a really robust group that has come under that banner, and it's keeps getting stronger, and I think we may see in its future ways to push our own boundaries and our own understanding of these concepts. And I think that's the real strength of the talk, the collaboration with Nathanson, and again, very much embodies the work we're about to hear from. So with that, welcome, and again, thanks to all those who put these events together, both behind the scenes and in front. Let's move on to the introduction of our esteemed guest, and for that, let me call Professor Tanguay-Renaud to the podium.
Thank you very much, Dean Sawson. So I have the pleasure today of introducing our 2013 Emet lecturer, who is Professor Antony Duff, who is, if I read correctly, the Russell M. and Elizabeth M. Bennett Chair in Excellence at the University of Minnesota, as well as an emeritus professor in the Department of Philosophy at the University of Stirling in Scotland. So it's a real treat, as Dean Sawson pointed out, to have, to welcome to Osgood somebody like Professor Duff, who's really a world-leading expert in the theory, the philosophy of punishment, as well, who's somebody who's internationally recognized for his expertise in criminal law and its structure. Indeed, Professor Duff is widely acknowledged as having catalyzed, and I use that word deliberately, renewed interest in criminal law theory around the world through his major works. And here I could cite many books, some of whom are Intention, Agency, and Criminal Liability, published at Blackwell in 1990, Criminal Attempts, Oxford University Press, 1996, Answering for Crime, Hart Publishing, 2007. And when I say catalyze, I mean that Professor Duff is one of these forces of nature who was now groomed entire generations of thinkers about the criminal law, either by teaching them, by supervising their graduate work, by examining their doctorates, by inviting them to one of the 5 or 6 international conferences that he organizes every year, relentlessly and selflessly commenting on their work, partnering with them in the context of countless transnational collaborations, publishing their works in one of the many collections of essays that he has published, or the Journal of Criminal Law and Philosophy, which he recently founded. In fact, I myself have many debts to Professor Duff. He was one of my doctoral examiners. I don't know what possessed him on that day, but he decided to pass me, which means that I can be here today to introduce him. And in fact, he was also the doctoral examiner of my own doctoral supervisor, John Gardner, who is the professor of jurisprudence in Oxford and also calls Antony a mentor. Professor Gardner was our 2008 Emet lecturer here. Victor Tadros, who's going to deliver one of the Pierre Genet Memorial Lecture next week, would also refer to Antony as a mentor. Massimo Renzo was here earlier this year giving a seminar at the Nathanson Center, would also call Antony a mentor, and the list goes on and on. In fact, Professor Duff is really also a dear friend of Osgood and of the Nathanson Center. In 2010, he came to Osgood from the UK at his own cost, always bringing with him his lovely partner in life, Professor Sandra Marshall, as well as an army of collaborators who agreed to provide free commentaries for a conference on rethinking criminal law theory that I was organizing with Professor James Strobopoulos. And late last year, he and his new pet project, the Robina Institute for Criminal Law and Criminal Justice at the University of Minnesota, also partnered with the Nathanson Center to organize an international conference on criminalizing and criminalized states, which some of you might have attended. And he's also expressed interest, and that's a great thing for us, in pursuing even more ambitious projects with us in the future, and we're grateful for this. Yet despite all this willingness to go down in the trenches, to build an entire field from the ground up, Antony Duff is also an unstoppable and careful generator of influential ideas. In addition to the books that I mentioned earlier, he's also published Trials and Punishments, Cambridge University Press, 1986, Punishment, Communication, and Community, Oxford University Press, 2001, and the list goes on. These are all landmarks books which anybody who has interest in criminal law ought to read. Furthermore, he recently led a 3-year interdisciplinary study of the criminal law, and more specifically the criminal trial, and with 3 colleagues produced the Trial on Trial, which is basically a collection of 3 volumes, which for the first time really takes the trial seriously and seeks to theorize it. And this study was funded by the Arts and Humanities Research Council of the UK, the AHRC, which also funded then a subsequent 4-year project led by Antony on criminalization. And this project, again, produced another 4 volumes of essays, as well as 3 monographs by some of the collaborators in the group. In fact, over the years, Professor Duff has managed to raise well over £1 million sterling in research funding for his project, something which I would say, euphemistically, is slightly out of the ordinary for somebody who primarily defines himself as a philosopher. And the fact that he was recently instrumental to the $8 million endowment of the Robina Institute at the University of Minnesota might well make him one of the closest things that we have to an academic superhero. And I say this, wearing at all times, at least as I know him, wearing at all times is distinctively stylish British uniform, tie or bow tie, perfectly tailored suit, trilby hat, and trench coat to face the element. Now today he's wearing a Renaissance tie, and I saw him outside with a French beret, so there might be something happening here, and we might find out in his talk. But the idea of a superhero is a true image. If you saw the poster that we came up for this, that we developed for this lecture, you'll see that we cast him in red right there, like Che Guevara looking at the horizon. And originally we had a halo around his head, and we thought, well, he's talking a bit too much about crime. Maybe we shouldn't have a halo there. So now it's a box. But this is truly a superhero, and not just an academic superhero. Professor Duff is also a public intellectual, has contributed to countless commissions, and taught judicial committee courses. And ironically, I would say his only flaw, and I don't know if I can call it that, is that Professor Duff is really a glutton for punishment, right? He not only studies punishment, but he's also somebody who's willing to, get down and dirty for the profession. So in 2008, he chaired one of the main subpanel of the research assessment exercise, the infamous RAE of the Higher Education Fundings Council, which fund British university, in which he had to review publicly and rank the work of his peers, which is not an enviable task. Now, thankfully, his brethren have recognized his greatness. They have named him a Fellow of the Royal Society of Edinburgh, as well as a Fellow of the British Academy. And today, then, we're glad to have him with us, to be able to celebrate somebody like Professor Duff in the context of one of our most prestigious lectures, as Dean Sawson so accurately pointed out. Now, some years back, the Emet Fund partnered with the Jack and May Nathanson Center, which explains the kind of themes that you see recurring in the lectures over the year. The center focuses on transnational human rights, crime, and security. But fortunately for us, Professor Duff has now decided to turn his gaze to questions of transitional, transnational, and international criminal law. And today he's kindly accepted our invitation, or should I say our called to account, to use an expression that is dear to him, for his most recent thinking on the topic in a lecture that is entitled, as you can see on the slide, Process Not Punishment, the Importance of Criminal Trials for Transitional and International Criminal Law. Now, as is now customary for the Emet lecture, Professor Duff will speak for about 50 minutes, and then he will entertain a few questions, and so far as we have time. But there will also be tomorrow a seminar from 2:30 to 4:30 p.m. in room 2010, to which you're all cordially invited, in which we're going to dig deep into his argument and see whether it is really true. If you wish to attend, want a copy of the lecture, you can email me, I'll send it to you. And I'd point out that right after the lecture, there'll be a small reception, again, to celebrate Professor Duff's visit at Osgood. So without further ado, I call to the stand Professor Antony Duff. Thank you very much.
Well, thank you very much. The trouble is that kind of build-up you get. It's bound to be a letdown now. Nothing I can do will achieve the heights of Francois's commendation. So thank you, Francois. Yes, I'll take off the shirt in a minute. It's very nice to be here. Thanks very much to the law school and to Nathanson for inviting me. It's nice to be back in Osgood. The sun is shining. It's even colder than Minneapolis, but that's okay. We can cope with that. It's great to be here, and I thank you for the introduction as well, which I'm still blushing over, and I'll try and get over quite soon. However, to business. If this works. Of course it works. I want to talk about criminal trials, which have been somewhat under-theorized by normative theorists. They talk lots about crime, about criminal law, what its scope should be, what should be criminalized, what the principles of liability should be, a lot about that. They talked even more about punishment and how that should be understood, what its aims should be, how we should sentence and so on. They not talk so much about what links crime and punishment, the criminal process which culminates in the trial. That's been relatively under-theorized by normative theorists. And part of my aim is to correct that under-theorizing. As my colleagues and I did, we hoped some years ago with the trial on trial, I'm now trying to push that forward a bit further and see how far we can go beyond domestic trials to look at transitional justice and international criminal law as well. And I can cite Sandra Marshall, my partner in crime here. She was also a co-author of the original book, so the ideas here are also her fault. If I get difficult questions, I'll say, well, she can deal with that one. She's here to help. Anyway, why do people pay... I mean, the criminal trial looms large in literature, in films, in television, all these wonderful trial scenes of high drama. So why are theorists so uninterested in the criminal trial? One answer is, well, they assume perhaps that the trial is of only instrumental importance. Its entire point is to find those who get punished. That's all there is to it. So why bother spending time theorizing a merely instrumental process which aims at punishment as its end result? The second reason might be there are actually anyway very few trials. The vast majority of cases, certainly in Britain and the States, 90-something%, are settled by guilty pleas. There's no contested trial. And most of those are emerged from plea bargaining behind the scenes. So trials on the ground don't loom very large. So again, why bother theorizing them, you might think? Because they play a very small part in the actual process of criminal law. Most of it's done by prosecutors, making bargains with the defense counsel, and then a formal guilty plea, and that's all there is to it. But that's a mistake, I think. Even in the context of domestic criminal law, our ordinary everyday criminal trials, the trial means more than that kind of view allows, and it's more important than that it allows. And I'll try and say in part two why that's so. The trial's importance is not just to do with picking out those who get punished. It has an importance which transcends punishment, which would retain even without punishment. The trial's still important. That's true in domestic criminal law. It's even more true, I think, in the context of transitional and international criminal law, where the trial takes on even greater importance independent of punishment as its possible end result. As David Lubin noted, in these contexts, especially international law he was talking about, as he put it, the emphasis shifts from punishments to trials. The centre of gravity lies in the proceedings, not in their aftermath. In the trial, not the punishment. And Lubin finds that puzzling, as he would if you think the whole point of trials is to get to punishment, then why have trials without punishment? I think if we think carefully about what trials could mean, we'll see again how in these contexts too, of transitional justice and international criminal law, trials can be important other than as means or preludes to punishment. And I'll argue that in sections 3 and 4. One important point to bear in mind, I'm talking here about a normative theory and a kind of what trials ought to be, what aims they should serve in the domestic context and elsewhere. I'm not trying to describe or justify what goes on in our courtrooms or indeed behind the scenes, behind our courtrooms, which is often unjustifiable. My aim is a normative theory of what trials should aspire to be in domestic context and also internationally. So bear that in mind. So don't say, look, trials aren't like that. I know they aren't. But they should be like this, I'll say. Okay, so I want to begin with the domestic context of our ordinary domestic criminal trials, to sketch an account here, drawing on the work I did with my colleagues, of what trials should aim to be in domestic criminal law. Again, the familiar view is instrumental. The primary point of the trial on this view is to identify those who committed crimes, accurate truth-finding about criminal behaviour. The point of that is simply to pick out those who get punished. That's all there is to the trial, is picking out those who get punished because they committed crimes. Of course, the truth that trials seek on this view is a limited truth. They ask, did this defendant commit this crime as defined by law? That's all they ask. They don't explore the nuances of the context, the background, the motivation. They just like, did this person commit this crime as defined by the statute? End of story. So the truth they seek is itself a limited truth. It's also true, though, that if you look at the actual trial procedures, they seem ill-designed to pursue the truth. They're surrounded by constraints and rules and principles which seem to hinder rather than help the search for truth. The court must presume innocence for a start. It must presume the person innocent until proven guilty beyond reasonable doubt. They're also constrained by a whole bunch of evidential rules and proceedings. Rules about what evidence can be introduced, what evidence is excluded, that the defendant can stay silent and isn't required to speak. All these constraints on the trial process seem to hinder the unfettered search for truth. And people like Bentham thought this was nonsense. You should have a free search for truth and all these constraints get in the way. One could say, though, that there is a point to these constraints. And this is a further point of the trial. The trial is also to protect defendants and citizens against the state's coercive power. If you're suspected of crime, you face the might of the state. And that's rather scary. The trial process protects you against being unreasonably, arbitrarily, over hastily punished as a criminal. And you can see the various constraints on the trial process, which hinder the unfettered search for truth, as there to protect defendants against the coercive power of the state. So the trial then has these, the aim is still truth as a means to punishment, but you constrain the pursuit of the aim by these side constraints that protect defendants against the state's coercive power. It's still basically an instrumental story, but you build in these protective constraints as part of the process. And that's the simple story about the trial, which many theorists, I think, accept. But it's too simple, you were surprised to hear. It doesn't do justice to a blank screen, or indeed to the defendant's role in the trial. On the instrumental view, the defendant's there as the object of the trial. We ask about him, did he commit the crime? He's there as object, not subject, if you like. But in fact, if you look at even the trial procedures, the defendant plays a more important role than that. For a start, he is expected to enter a plea, to plead guilty or not guilty to the charge. He used to be forced. If he refused, he would then be put under pressure, physical pressure, to actually enter a plea. That doesn't happen now, but still, we expect the defendant to plead guilty or not guilty. That's seen as important. He's also expected to be fit to plead. If he's not fit to plead, if he's, at the time of the trial, mentally disordered, insane, can't understand the process, then he can't be tried. The court must ask, can this person understand what's going on? Can he take part in the trial as a defendant? If he can't, then we can't try him. So the trial's own process gives the defendant a rather active role. He's there to enter a plea, to attend the trial, and also to understand it, and through counsel take part in it. And this instrumental story doesn't explain why the defendant should have that kind of active role. So we need an account which goes beyond the instrumental story to explain why the defendant should figure as an active participant, at least in intention, in the trial. And here's the story. The trial, on this alternative view, is a process of calling to account or calling to answer. The defendant's there to be called to answer a charge of wrongdoing, and being called to answer is to be given an active role. You're there to answer the charge and to answer for what you've done. The criminal law itself defines a range of public wrongs, of wrongdoings which concern all of us collectively as citizens. The law says these wrongs are wrongs you'll answer for publicly. These wrongs are not just private matters, they're wrongs which concern all of us as a polity. That's the content of the criminal law. And the trial is then served to call to account those accused of committing these kinds of wrong. If you're accused of a wrong, you must answer to that charge at your trial. You're called to trial and says, how do you plead, guilty or not guilty? You answer the charge that you did wrong. And you plead you can either confess you're guilty, or you say not guilty, which says prove it, or I didn't do it. So you're called to answer to the charge by the court speaking for your fellow citizens. If your guilt's proved, then you answer for that wrong. You're expected to answer for what you've done, to accept conviction, and after conviction, of course, punishment. So the trial is a process through which an alleged wrongdoer is called to answer this charge in public by his fellow citizens. He's called to answer to the charge, to offer a defence if he has a defence, and if convicted, then to answer for his conduct by accepting conviction, censure, and punishment. And that's why the defendant has an active role in the trial. The defendant is there not just to be judged, but to answer for what he's done. Seen in this light, seen as according to account, the trial instantiates three kinds of good. First, they affirm the authority of the law in three ways. First of all, by bringing a person to trial, we affirm the law's authority as to finding the wrongs which you get tried. A trial for murder or rape or theft or drunken driving reaffirms the laws which define those as wrongs. We show we take them seriously as wrongs by putting on trial those who commit them. So it affirms the law's authority to define these wrongs as crimes. It affirms the law's authority to call to account those who are charged with such crimes. It's authority over the defendant, who is called to answer in this court. And in answering, the defendant accepts the authority of the court. Of course, they might refuse to answer because they reject the court's authority. That's also important as a public statement of defiance. They refuse to enter a plea because they say this court has no authority to try me. So again, the trial itself is an affirmation of the law's authority over the defendant and over all citizens. The trial, if you like, enacts the authority of the law to call wrongdoers to account and to say to citizens, here's the way you deal with wrongs. You don't take private vengeance, you don't pursue vengeance yourself, you go to law. You look to the law to affirm the values and to call the wrongdoer to account. So the first good the trial instantiates is the good of affirming the law's authority over citizens, including the defendant and the offender. Secondly, it also does justice to victims of crime. Victims of crime have suffered not just harm, but also wrong. They've been wronged by the person who attacked them. That needs to be recognised by their fellow citizens. And the way to recognise that someone's been wronged is to call to account the person who wronged them. There are other things we do other things to support victims. But one thing we do to show we take seriously the wrong they suffered is to pursue the wrongdoer and call them to account. So in putting on trial a person who's done the wrong, we thereby do justice to the victim of the wrong. As someone who has suffered wrong, we recognise that and reaffirm their standing as citizens by pursuing their wrongdoer. And that's important too. It's often said that victims aren't given enough of a status in the trial. And there's truth in that. But still, the very process of putting on trial the person who did the wrong, putting on trial the person who mugged you or assaulted you or stole from you, that process takes seriously the wrong you suffered as a wrong and thus recognises you as a person with standing. So the trials do justice to victims by calling to account the wrongdoers, but also do justice to offenders. The rhetoric of criminal law these days, certainly again I'm talking of Britain and the States, I didn't know about Canada, the rhetoric of the criminal law is often that of, here's we the law-abiding citizens, there's them, the enemy, the offenders, the outsiders who need to be cabined, constrained, deterred, incapacitated. The whole language of the war on crime is a language of we the law-abiding and them the outsiders. The criminal trial denies that. The criminal trial affirms the status of the defendant, innocent or guilty, as a citizen. He's called to account by his fellows. He's called to answer to his fellows what he's done. So the trial itself, as a process of calling to account, treats the offender as a member of the normative community. He's one of us and answers to us as one of us for what he has done. So it's crucial that the trial, this will be important later on, the trial recognises and treats the offender as a responsible member of the community with answer for what they've done. In that way, the trial is an essentially inclusionary procedure. It doesn't push the offender away as being an enemy. It brings him within the community as someone who must answer within this community for what he has done. And that's the third good which trials bring, of reaffirming the offender's status as a member of the community, who has answered to his fellows for what he has done. Those are the goods internal to the trial, affirming the law's authority, recognising victims and offenders as members of the polity. The trial can also then serve certain further aims, which are prominent in so-called restorative justice, the aim of reconciliation. By calling the wrongdoer to account, we thereby reconcile the wrongdoer, we hope, to the victim and to the community. That's the aspiration, if you like. And that's an aspiration shared with those who advocate restorative justice. But bear in mind that this is a very limited kind of reconciliation. The criminal law is not concerned with our dealings with each other as friends, as colleagues, as lovers, as neighbours. We aren't trying to reconcile people as friends or neighbours. The law is concerned with our dealings as citizens with each other, a rather formal, often distant relationship as citizens in a liberal polity. The trial brings a kind of formal reconciliation. If my wrongdoer has been tried and then convicted and punished, that process itself is a formal reconciliation between me and him, between him and the rest of us. He's now been put on trial, he has, as we say, paid his debt when he's been punished. The trial itself, though, is that process of reconciling offender and wrongdoer. By this very process of calling to account the wrongdoer as a member of the political community. So trials which instantiate the goods of authority and of calling to account and of recognising victim and offender as citizens also thereby provide a kind of formal reconciliation between citizens who can now still live together as citizens because the process has been properly undergone. That's domestic trials, as they should aspire to be. The question then is, can we find a rule for trials of a similar kind in other contexts than domestic criminal law, in particular in transitional justice and in international criminal law? I'll start with the transitional case. So we're dealing here, this is a very sketchy definition, if you like, situations where a polity, a nation is trying to reconstitute itself, reconstruct itself after a process of turmoil. After some years of authoritarian rule involving oppression, after years of civil conflict, which have now come to an end, now we try to start again to rebuild society. And of course, what went before, the oppression, the civil conflict, involved large-scale serious wrongdoing. The aim is now to rebuild a polity which can instantiate justice and which can achieve the common good of all its members, including those who were in the past oppressors or on different sides in civil conflict. The trouble here is that justice now figures both as an end but also figures in the means. We want to achieve the just end, but also, if we can, by just means. The aim is to rebuild a just society in which people are recognised as citizens, in which their rights are respected. That's the end aim of justice. But can we do that through just procedures? Can we have justice in the transition from conflict to a reconstructed peace? That's a challenge for transitional justice. And the question is, what role can criminal law play and criminal trials play in that transition from conflict to the hoped-for stable and just peace? Because the problem is obvious, in a way. We're dealing with serious, widespread wrongs, with killings, with torture, with detentions, with expulsions and so on, committed on a large scale during the conflict. How do we cope with those? Can we just ignore them? Well, that seems inadequate. We can't just ignore that kind of wrongdoing. Now, seen through the eyes of normal justice, of course, those wrongs require punishment. What you should do now, when justice is restored, is you pursue, prosecute, and punish the wrongdoers for the wrongs they committed. That's what justice cries out for, if you like, seen through the lens of normal justice. There are these wrongs that are clearly massively criminal. Justice demands they get punished. On the other hand, of course, if you go down that road, you try to pursue, prosecute, and punish the wrongdoers as seriously as they deserve, that will hinder rather than help the move towards peace and justice, because those who commit the wrongs, who face then punishment, will obviously be less inclined to take part in the process of building peace. They're more inclined to carry on fighting to resist. So that justice demands, it seems, punishment. Punishment proportionate to the crime, so punishment which is very severe. But to try to impose those punishments will hinder rather than help the move towards rebuilding a just society. And that's the tension within transitional justice. How can you do justice to the past crimes when it seems justice demands a kind of punishment which hinders the rebuilding of justice for the future? Can criminal trials help here? Can they, if not, can they at least reduce this tension by finding a way forward of doing justice which doesn't involve the kind of heavy punishments which would hinder the process of rebuilding? But of course, if trials are simply about punishment, they can't help. If trials serve only to pick out those who get punished, that's the point of having a trial, to pick out those who get punished, then they're part of the problem. Because then by having a trial, you say, right, who will be punished? But punishment itself is what's going to stand in the way of rebuilding peace. So if trials are simply instrumental towards punishment, then they can't help. But there are other aims trials can serve. One aim might be that they aim to establish truth. And we often hear, it's often said in this context that what's needed for transition from conflict to peace is truth. People have a right to the truth in this context. And often theories of transitional justice build in a right to the truth as part of what's required. But then why should we look to trials for that rather than to truth commission? Bearing in mind, again, that trials can establish only a very limited kind of rather formal truth. The trial asks, did this person commit this clearly defined offence? You might think the truth required for reconciliation is a much deeper, wider truth than that. We want to know the truth about the motivations, the context, who did what to whom, various kinds of collective wrongdoing. So if the aim is to find the whole rich truth about what happened, trials seem ill-suited to that end. You need a truth commission, not a trial. But yet, if we ask more carefully about truth here, we might see a role for criminal trials. We ask more carefully about the voices and the verbs in terms of which we understand this right to the truth. And we ask these questions, I'll go on to ask, we can see more clearly what role trials might play. So, question one. If we talk about the right to the truth, I'm getting a blank screen. Whose right is this? Who has the right to the truth in the context of transitional justice? One answer is, of course, the victims. Those who suffer the wrongs, directly or indirectly, have a right to know who wronged them and how and why. So one right bearer is clearly the victims of the past wrongs. Maybe, too, all citizens have a right to the truth, not just because we might see ourselves collectively as indirect victims of the wrongs, but also we're the peace builders now. We want to rebuild the truth, but we need to know the truth before we can start rebuilding. So the right to the truth is one we all have as citizens of this fractured but now reconstructing polity. Maybe too the perpetrators have a right to the truth. I'll come back to them shortly. So one question is, whose right is this right to the truth? The other question, more importantly, is what kind of right is this? Is it simply a passive right that the truth be established? That the truth be told somehow, that the truth be recorded in some suitable documents? That's all it is. The passive right impersonally, that the truth be established. Is it more admittedly a passive but still now personal right? The right to be told the truth. Is my right as a victim to be told the truth about who did what to me? Is that the right we're talking about here? Or is it perhaps also an active right? Not just that the truth be told, or to be told the truth, the right to, in various ways, to declare or to witness the truth. So are the appropriate verbs here, if we try to articulate the right to the truth, are the verbs here active or passive? Do we talk about the right that the truth be discovered or proved, or right to declare, to witness, to confess the truth? When you get clear about what verbs are appropriate here to see what the right is and how it can then be fulfilled. And here's where criminal trials can come in. If the right to the truth is simply a right that the truth be found and established, then you need a truth commission. That's simple. But suppose the right is a right to certain kinds of action, often symbolic action, actions such as declaring, witnessing, confessing. If the right to the truth is a right to certain kinds of action, then trials can have a place. Because at the trial, the perpetrators are called to account for their wrongs. called to answer for their wrongs by confessing their guilt or offering a defense. They're called to engage themselves in the activity of truth revealing, truth declaring, truth confessing, and so on. Victims themselves can then, and witnesses, then get a chance to declare, to bear witness to the truth of what happened to them or what they saw being done. And the court, speaking in our collective voice, then returns a verdict. It acquits or condemns or convicts and censures. So the trial then is a forum not just in which truth is impersonally established. We can say the truth is being performed in various ways in the trial. The truth is being asserted, declared, confessed, witnessed, confronted. The trial, in a way, is an enactment of the truth in various ways. We are called upon as witnesses, as victims, as defendants, as members of the court or the polity, to take an active role in this truth process. Now, if the right to the truth is a right to that kind of active process of truth performance, then trials can help to fulfill that. Because trials are the forum in which these kinds of performance take place in a formal, organized, and symbolic way. And it seems plausible, if you ask what kind of right to truth matters in this context, it is a right to this kind of active truth. What matters for rebuilding a polity is not just that truth be known somewhere, somehow, recorded formally, but that the truth be engaged with in these active ways of declaring, confessing, admitting, charging, and so on. Seen in this light as ways in which the truth can be formally enacted or performed, trials can still instantiate the same goods we saw in the context of domestic trials. The trial reasserts the authority of the law which was violated. It reasserts the norms that are at stake here as being our collective norms, and the authority of the court itself to administer those norms. So an important part of the trial process is to reassert the norms that were flouted in the previous conflict, say that these are indeed the norms that we're committed to. Again, the trial recognizes the victims of wrong as victims of wrongdoing, which concern us all. It reaffirms our standing as citizens, who are hereby formally, if you like, recognized as having suffered wrongs, whose perpetrators are now called to account. But also, and crucially again, the trial recognizes the defendants and perpetrators as members of the polity. They're not monsters, they're not enemies, they're our fellow citizens. And that's a dramatically challenging thing to do. Because you are in the aftermath of civil conflict or of oppression, and you as a citizen, as a witness, a victim, are asked to recognize the person who oppressed you, the person who tortured you, as a citizen who is called to account in a criminal trial. So in the criminal trial, unlike warfare, unlike execution, unlike disposing of people, the criminal trial is itself a way of recognizing and affirming political community. We call the defendant to answer as a citizen for what they have done. And that's an inclusionary, not an exclusionary move. So trials, seen in that light, make enormous demands on those concerned. They demand of the perpetrators that they face their victims. They demand of victims they face their perpetrators and treat the perpetrators as citizens who will answer what they've done. So trials as this kind of process are central to, but also demanding, for just that reason, central to the process of peace building. In the trial, we see a formal reconciliation of victims and offenders and others being enacted in a formal public trial. So I think a crucial point about trials in this context, and we'll see also in international law, is not just they do justice to victims, which they can do, but they do a certain kind of justice to perpetrators by treating them as citizens, not as outsiders or enemies or monsters. And the triumph of a trial is to achieve that, not just to vindicate the victims, that's crucial, but also to treat the offender as someone who will be called to account by his fellows. That's the crucial point. So trials, seen in this light as calling us to account, can instantiate these goods, which seem to be crucial to a process of rebuilding. We want to rebuild a community in which we all belong as citizens. And the trial itself instantiates that kind of rebuilding. It says, here we are, here's the perpetrator and the victim and witnesses, here we all are as citizens in this formal process of a criminal trial, in which you answer to us for what you have done. those are the goods internal to the trial as a process calling to account. Oops. I just mentioned these 2 points. One point is this: recall that our ordinary trials set quite tight constraints on truth-seeking. The rules of evidence exclude a whole range of kinds of evidence as being not admissible, and the defendant can stay silent. They're not required to enter a plea. You might think if the point of the process is to enact, perform, declare the truth, then defendants shouldn't have the right to remain silent in this context. They should have to answer for what they've done. They shouldn't be allowed to sit there and say nothing. I'm not sure. The right to silence, especially, if you think about that one as one of the main barriers to the truth being enacted. In the domestic context, the right to silence is a kind of secondary right. Ideally, in a domestic trial, the defendant would speak for himself. He would say, yes, I'm guilty, or no, I didn't do it, and here's why. They would engage. If you are why, in that context, allow them the right to silence? Well, it's a further kind of protection. If they were required to speak, that would open them to all kinds of, if you like, bullying, oppression by the court, by the state's power. It's a defense for the defendant not to be required to engage, to be allowed to take no part without being penalized. That's an important protection in the domestic context. You might say that morally speaking, if the trial's a just one, then the defendant ought morally to speak. But we don't make that moral ought a legal ought. We don't enforce it by law. Now, in the context of transitional justice, you might think the moral demand to speak is indeed even stronger. Whether you're a defendant who's innocent or a perpetrator who's guilty, you're there as a defendant in this important process. Surely you owe it to your fellows to speak, to play your part in this rebuilding process. So I think that morally speaking, the demand to speak, to take part, is even stronger here than in the domestic context. Should we say that in this context, there is no right to silence? You're required to speak if you're on trial. Required, well, on pain of what? On pain, I suppose, of being convicted and punished as a refusenik. And even here, you might think we should leave defendants that room to hold back, to remain silent. They might still be convicted and condemned, but they are not going to be forced by the threat of punishment to take part in the process, which they might regard as illegitimate. So I think, I'm not sure of this, we should maintain the right to silence even here. But it certainly comes under even more pressure here than in other contexts. You might wonder too again about the victims. I think it's often said in our domestic trials, victims have no real standing. They report their crime to the police, and then that's it. They might find out what's going on, they might be a witness, they might not, but they don't have any formal status in the trial. And there are issues to be asked in domestic law about what status, if any, they should have beyond that. Should they have some formal standing in the trial? Should they get to speak, tell their story in the trial, and a victim impact statement or what? You might think again, in the context of transitional justice, the victim's demand or need to be heard is even more stringent, given what they've suffered. You might think there should then be a room within these trials for victims to have a formal, not to say in sentencing, not to say in the verdict, but at least to be heard in the trial. Again, there's some force to that thought. So we might say that in this context, then, trials should be in some ways adapted. We should give the victims perhaps a more formal role, at least as witnesses, who will always be called. Maybe we should wonder about the right to silence. But those, in a way, are subordinate issues. I think you still see that the trial, as a process calling to account, can play this important role in transitional justice context. Maybe with some adaptation, but still the core is still there. That's the goods internal to the trial. But of course, the trial isn't an end in itself, and that process isn't an end in itself. We have a further aim in mind as some kind of reconstruction of reconciliation. Can the trial serve these further aims? Can it help to restore the rule of law? Can it help to reintegrate victims and offenders as citizens? Can it help to reconcile them and to rebuild the kind of civic trust which apology requires? In a way, I've already answered that question by saying, yes, they can. They can serve those ends by a kind of symbolic enactment of them. The trial itself enacts the rule of law, it enacts the reintegration of victims, offenders as citizens who are there taking part in the trial. it thus enacts a rebuilding of civic trust, because by taking part in the trial, that's a context in which we behave as citizens towards each other. And this provides a kind of formal reconciliation. We're there as playing our roles in the trial, as victim, witness, defendant, and so on. But this might sound already somewhat over-idealized. I don't want to get enormously, naively over-idealized. There are clear limits to what can be done here by trials. For start, trials can only be part of a much larger process. They're one part of a process of working from conflict towards peace. They aren't the whole thing. They're simply one strand in wider efforts of various kinds to rebuild peace and trust. Partly because they offer only a very limited formal kind of recognition and reconciliation, in the way that domestic trials do. The trial is a formal procedure in which people have their formal roles to play, and those roles are important civic roles of victim, witness, defendant, and so on. But they are simply roles. They aren't our entire persons, if you like, engaged here. We're engaged formally in a formal process, which is, it matters symbolically, but it's only symbolic. It's not the whole thing. It's also true, as I noted, that trials make very heavy demands on all those involved, especially on victims and witnesses, but also on perpetrators who have to face each other in the court and engage as citizens in this process. So trials are very demanding. And for that reason, although we can require defendants to appear for trial, we might think that victims can't be required to appear to any part in the trial. Maybe they recognise a moral duty, but it'd be hard to enforce that by law. And of course, it's true too, the whole trial process depends upon enough willingness to accept the law's authority for the trial to take place at all. The defendant must at least go through the motions of accepting the court's authority. They're there they're trained and gagged. That's not a trial. That's a travesty. So the trial can even take place as a trial only if there is some minimal willingness to accept the law's authority, and that itself presupposes that quite a lot has happened in the transition from conflict towards peace. So I'm not saying trials can do the work. Of course they can't. But trials can play an important symbolic role in the process of transitioning from conflict towards civic peace. So much for the time being then for transitional justice. Moving on rapidly, skimming even, to finally international criminal law, which of course comes in many different guises, many different tribunals deal with it. So our focus, make life simpler, make it manageable, on the International Criminal Court as a particular manifestation of international criminal law, and within the International Court's remit, only on one kind of crime. The court deals with crimes of war, aggression, genocide, and crimes against humanity, which are defined partly in these terms here as a list of serious crimes, including murder, torture, rape, and so on, committed as part of a widespread or systematic attack on a civilian population. So the definition of the crime against humanity gives it this collective character. It's an attack on not an individual, but as part of an attack on a civilian population. And think about that kind of crime. And those instances of that kind of crime which are committed within a particular nation by its own members against each other. So crimes whose impact is local or international, committed within a country against its citizens by either official bodies or unofficial bodies within that country. So the crimes themselves then are materially internal, not international. They occur within the polity, but yet they fall within the remit of the ICC. So I want to focus on those kinds of crime and that court dealing with them and ask what's going on here, whether trials here can have the kind of value I said they can have in the domestic context or in the context of transitional justice. One thing to bear in mind is that the ICC operates under its statute with the so-called principle of complementarity. Priority belongs to the state within which the crimes are occurred, the state with jurisdiction over them. The ICC can try those cases only if that state is unwilling or unable to pursue the cases itself. The ICC is a kind of fallback. The first move is that the local state will investigate and prosecute. If, and only if, they can't or won't, then the ICC may take the case on, and that's going to be important. So again, the question is, what role can the trials that the ICC should conduct, though it's very slow doing so, play here? again, can these trials be more than a way of picking out those who get punished? In particular, can they instantiate the kinds of good which I've argued we can find in domestic trials? Again, the first answer is yes, of course they can. You won't be surprised to hear. They can reaffirm the law's authority because international law defines what the ICC calls these most serious crimes of concern to the international community as a whole. And it calls to account the wrongdoers and thus puts an end to impunity for those who perpetrate such crimes. So it reaffirms the authority of the law which these people have violated. That's the first good. It does justice to the victims of those crimes by recognizing their wrongs, by calling to account their perpetrators. That's also the good it can hope to achieve. And also, again, crucially, can do justice to the wrongdoers themselves by treating them not as outlaws, not as enemies, not as enemies of the human race, but as fellow members. Again, that's an important move to make. Historically, often people who did these kinds of crime were treated as outlaws, as enemies of the human race, as pirates used to be called. You can exterminate them, you kill them, you dispose of them, you don't put them on trial, because they aren't members. So an important move, a crucial move for the ICC is to say, no, these people go on trial. They too are fellow members of the normative community who answer to us what they've done. And that move to bring the perpetrators within the community is a crucial one. Recall, at the end of the Second World War, the question was what to do with the Nazi leadership. One answer is you just kill them, you exterminate them if you can. Another answer is you put them on trial. And although there are all kinds of motive for putting on the Nuremberg trials, one proper reason is you put them on trial as showing that they are still fellow members. Whatever they've done, they're still members of the normative community and they answer to us what they have done. So the ICC, the trying people who've done these things, reaffirms their standing as members of the normative community, and that's crucial. That all sounds very good, but I've slid over a crucial question. What is this community? In the domestic context, and also that of transitional justice, you're dealing with a particular political community within which these crimes happened, whose law is affirmed, and victims and offenders are treated as citizens, members of that community. So in the domestic context and the TJ context, we're dealing with identifiable political community, with a nation, within which the wrongs happened, whose laws are being reaffirmed, whose members are being treated as members, and so on. That's the community there. Well, how about the ICC? Whose law is being reaffirmed here? Whose is this law that the ICC applies? What's the community of which both victims and offenders are members, and to which the court also belongs? When the court says, we call you to account through us to your fellows, well, who are these fellows? What's this community within which this trial takes place? So the trial, as I've portrayed it, depends upon some notion of community. The trial speaks in the voice of the political community to which victims and offenders and the court belong. It reaffirms the law of that community. That makes sense in the domestic context. But what's the community in the context of international law? In whose voice does the ICC speak with what authority? We know the voice in the domestic context, the voice is the voice of this polity. But whose voice is the ICC speaking? Well, here's one answer. It speaks for humanity. Humanity is this large community, all-embracing community, which we all belong as human beings. And for these crimes against humanity, as they are called, then for these crimes, you answer to humanity itself through the ICC. And that's the grandiose rhetoric of the ICC in some cases. We speak for humanity itself and call you to account as a human being for what you did to your fellow human beings. And that sounds rhetorically impressive, but also deeply suspicious as a substance. And one reason is simply this, that criminal law requires a political community. The criminal law is a political institution. It belongs in a political community. Now, you might have aspirations towards humanity as a community of a moral kind. You might say, recognize others as fellow human beings morally, respond to their needs, their concerns as a moral agent. That makes sense as an aspiration, at least. Humanity as a moral community. What you can't say is that humanity is a political community to which victims and offenders belong as citizens. That doesn't make sense. That's not a viable thought. So the ICC can't be speaking for humanity as a political community. There's no such thing. So here's another suggestion which seems to me to have more going for it. I'm still not sure. The ICC speaks and acts for the international community. I keep doing this. That community, let's suppose, is a community not of individual people, but of nations. That's the community the ICC speaks for, community of nations. So defendants and victims don't belong as individuals to this community. Its members are nations, not individual people. And it's this community of nations whose task it is to pursue these kinds of crime. And the ICC speaks on behalf, in that community's name, on behalf of the crime's victims, because in these cases which the ICC takes on, those victims have been betrayed by their own state. And that's why the ICC intervenes. An important point here is the distinction between nation and state. The nation is the political community. The state is, or should be, its institutional manifestation and mechanism. What happens with crimes against humanity is that the state lets down the nation whose state it is. And that's what gives the ICC the right to intervene. To explain that briefly, we're dealing here, don't forget, with cases where there is a state with a jurisdiction over these crimes, the local state, which has failed to investigate and prosecute for no good reason. Only then can the ICC intervene. The state has priority. And that's an important part of the background here, because when the state fails to pursue these kinds of crime, it makes itself complicit in those crimes. And that's what gives the ICC the standing to intervene, because the state has now betrayed its own people. Complicit in one of two ways. It may be, and often is, complicit actively. The state's own officials have perpetrated or instigated or consented to these crimes. And that makes the state clearly in advance complicit in the crime. Or maybe it's after the event. It fails to investigate or pursue the wrongdoers. But we're dealing here with attacks against a civilian population, not against individuals, but against whole groups. If the state fails to pursue that kind of wrong, it's saying, look, you don't matter. The wrong you suffered as a group isn't important. It's not worth pursuing. And that's to say, you aren't citizens, you aren't really members. So in failing to investigate these kinds of crime, the state is betraying its own citizens and denying their citizenship, in that way making itself complicit in the attack on them. When that happens, we say others then have the right to intervene. Other nations, other polities have the right to intervene on behalf of those citizens whose own state has let them down, to protect them and their polity against the state which has now betrayed it. That makes the ICC a kind of proxy. Properly speaking, still, the perpetrators should answer to their fellows whom they wronged. Ideally, properly speaking, the trial should take place within the polity, as it does in the case of domestic crime. When that fails, the ICC becomes a proxy. It acts on behalf of the citizens whose own state let them down. And that's why it's crucial to preserve the principle of complementarity. Ideally, the local state would try the cases. Only when it fails can the ICC intervene. So the point is here that the best the ICC can achieve on this view is a kind of second best or proxy justice. It can't speak in the name of, in the voice of the citizens, because they've been silenced by their own state's failure. It speaks on their behalf, doing what they should be doing for themselves, what they can't do for themselves. Oops, there's something missing there. It follows too that the ICC then can't achieve the further aims, which you might hope could be assisted by trials in the context of transitional justice, of rebuilding and reconciliation, because those are done within the polity. The ICC does it from the outside, does it again as a proxy. So it's at best a second best kind of justice. And that's the most you can do with ICC trials, I think. So ideally, you find the trials would be done locally. And that would bring it back into transitional justice. Only when that fails abysmally can the ICC have any proper role at all. That's to say, bear in mind, I'm talking only about these particular kinds of crime. With other international crimes which have an international impact, crimes of war and aggression, then the picture might be different. a different story there. But as far as the crimes against humanity go, which are committed within a particular state, and the best answer is the ICC has standing only as this kind of proxy, second best kind of criminal justice. Because the wrongdoers are called to account. They're called to account on behalf of those they wronged, but not by those whom they wronged. But properly speaking, for a criminal trial, the wrongdoers are called to account by their own fellow citizens whom they have wronged. So the story about the ICC is rather more downbeat than the story about transitional justice. There is still a place for criminal trials. They can still instantiate some of the values that the trial has, of calling to account and recognising fellowship, but only in a limited and rather second-best way. On which time-beat note, I better stop. Thank you.
Okay, so we have about half an hour for questions. Because it's being recorded and before this is going on YouTube, make sure that you have a microphone in your hands before you ask a question, simply so that we can hear your voice on the video. Any questions? Professor Van Berger.
Thank you so much for that. I'll confess at the outset that I'm still more troubled by the silence issue than, and perhaps you can say a little bit more about that. But
Francois, do I need this microphone? Francois, do I need this, or can I? Thanks. Sorry.
No, just that by the silence issue, and it relates to really the core of my question, which is how we imagine the trial that you're referring to. A trial can do this, a trial can do this. But the silence issue bothers me quite deeply for the reason that you state, which is if the point is to call you to account, to answer for the wrong, then it seems incommensurable with the kinds of protections of silence and self-incrimination. I take the point that it's a kind of second-order right where you would worry about other sorts of bullying, in which case, you might have all sorts of protections on the bullying. But if the heart of the trial is to have this exchange and to call account, it's a very odd sort of form when the shape of that could be imagined as being enter a plea through a lawyer and say nothing. So I realize you're not claiming this is how the trial is, but it seems to have sort of implications for how you would imagine a trial. In fact, that's the core of it. But I guess more to the point is I wonder, does a trial have to be adversarial to achieve this kind of normative goal? Could it be inquisitorial? And I guess more to the core of it, what's the signal feature of this trial that means we know it when we see it? So you drew a distinction between truth and reconciliation commissions and trials. And one might well say, this is just another form of a trial that achieves these ends in kind of a different form. So is it the tethering to punishment that's what makes it a trial to fall into this normative theory? I'm just a little unclear on what the it is when we're talking about a trial. Can it do this or that?
Okay. Thanks. Okay, let's start with the silence point. And are you as worried about silence in the domestic context as in other contexts, or is it?
I think conceptually I'm as troubled.
Okay, fair enough. I agree, it's a problem. But here's how I see it in the domestic context. Certainly we've got to this ideal picture where say the trial calls you to answer. And we hope, intend, expect you'll answer that call, which means more than just saying guilty, not guilty, also with a mean taking part, saying yes, but here's what really happened, and so on. So I agree that the trial aspires to be that kind of genuine two-way process between court and defendant. And so silence is then a hindrance. Silence then prevents the trial being what it aspires to be. In that sense, silence marks a failure. The question is whether in the domestic context we should, for that reason, not just urge the defendant to take part, but also require them legally to take part. And if they don't take part, then what? Then try them for silence and punish them for that. Why shouldn't we do that? Well, it seems to me that we do need, again, thinking about domestic context, to leave people that kind of space to resist. To say, I don't recognize your authority. I'm going to remain silent. So I think the most favorable case, from my point of view, is the political dissident who sees themselves as a political rebel. They're on trial for criminal damage, let's say. And they also say, I just don't recognize this court, it's having authority. And therefore I refuse to enter a plea. I refuse to play by the rules because I don't think you have the right to try me. That seems to be important. Okay, that doesn't mean the person gets acquitted. We don't say, right, fair enough, off you go. We still insist on trying them. But we shouldn't require them or coerce them by punishment to say, yes, I accept your authority. So in the case of the domestic trial, the right of silence is both a protection against various kinds of coercion, but also leaves the person that kind of space for expressing dissent. And that seems to be important. So we call you to answer, but we don't compel you to answer. You're still allowed to get convicted if you don't speak, of course. It doesn't save you from being tried. But so I think it does have some importance in the domestic context. Does that persuade you at all in the domestic context? I think it's a weaker case in the context, our context, but
I'm very persuaded by the tradition, like being within it. I'm very persuaded by the fact that it exists, but
not by the story about it.
Not so much. I mean, the notion that you could resist and then suffer punishment for a number of other things, if the reason the trial is there is to establish a kind of normative community, to establish certain kinds of relations between citizens, I guess you could invert the question and say, then what does the trial become when someone exercises this right that we've given them to not participate in that at all? I understand your point and I take it. I have to think more about it, but I'm not fully there with you.
No.
So.
I'll say one more thing, then go on to your second point, which is also important, that the trial treats you as a member of if you're the defendant, as a member of the polity. So we're treated being bound and protected by its laws and so on. And we insist on doing that. We insist on treating you as a fellow, like it or not. The point is that we then also leave you the right to make clear you don't see it that way. Your second point is also important, though, because any talk of the trial can't but start off being parochial. I start from a given system of trial. Say, here's how we do things, and here's how I understand how we do things. And I start off then with the familiar kind of adversarial process in Britain or America. At least that is rhetoric, not in its actuality. The question then is, and what else could a trial be? And I can't be saying that trials must be like they are in the Old Bailey. That would be absurd. So trials must be, no. And here's a distinctive kind of process. A process of calling to account an alleged wrongdoer. What's at stake is, are you guilty of the wrong? We ask you to answer to the charge, answer for the wrong if you did it. And what's at stake is not necessarily a punishment, I want to keep that separate, but at least a formal censure if you are proved guilty. And that's the core of the process, a calling to account for alleged wrongdoing. That certainly need not be an adversarial criminal trial. You have an inquisitorial process which has the same core meaning to it. So in that way, there are many different ways of instantiating that kind of process. And you're right, one could then have something called the TRC, which had that form as well. But what's crucial is it calling to account? Well, actually, no, pause a minute. And is its culmination a verdict of either acquittal or censure? Except for this point as well, which is important. In a domestic trial, the law itself isn't up for discussion. We take for granted the law is the definition of the crime, as that's the crime. Are you guilty of that? The defendant isn't invited or allowed to start challenging the law itself and saying, that shouldn't be a crime. Because he's told that belongs in another forum. So one kind of process says, here's the law taken for granted. We now apply that law and asking, is this person, are you guilty of this wrongdoing? In a similar way as well, sorry, I'm talking on too long. There's one more thing. One contrast between a criminal case and a civil case. In the civil case, I sue you for damages. I say, look, I mean, it's partly your fault, for God's sake. So the blame is divided between us. The criminal trial has less room for that. So the criminal trial is dealing with what's taken for granted in the trial as being a categorical wrong. The question is, are you guilty of it? A TRC might or might not have that kind of feature as well. It might be in a TRC more is up for negotiation, for discussion, for argument. So I'm not saying that only trials of this particular kind can be the process. I'm saying here's a valuable process, according to account, which is instantiated in this way in criminal trials of this kind, but it has a part to play. So when you turn to the context of TJ, again, I want to say is this process can have an important part to play. Whether it's done by something called a TRC or a trial is perhaps less important. Yeah, I should be clear about that. Thanks.
This is in some ways a follow-up and in some ways not. Just some technical quibbles that have been occurring to me while I've been listening. You're a visitor to Canada, I assume, but if you assaulted Francois, there's no question that Canadian courts would take jurisdiction.
Damn.
Right? Your non-citizenship is not an issue.
And likewise, if he assaulted me, I hope.
Well, either way, really.
Yeah.
So I'm not sure citizenship is really the right word. And there's an interesting line of cases that I was likewise thinking about that have happened in wartime, where allegiance was the key question, where someone who had no allegiance to Canada, who was doing certain acts in Canada, might be guilty of murder or assault, but they wouldn't be guilty of treason because they had no allegiance. So that's a different word. And then there are all those range of cases now, like piracy and various other crimes, where Canada will take jurisdiction over Canadian nationals who are abroad. And then there are instances likewise in wartime where military tribunals will take jurisdiction over people that have no allegiance, no citizenship, but who are subject to the military authority abroad. So I'm wondering how you fit all those interesting cases into your general theory.
All of them would take quite a long time. The first point is a crucial one. It does seem to me that if we try to understand criminal law as a particular kind of political institution and ask how we understand its authority, then citizenship is a crucial part of the first answer. It's the law of a certain citizen body, it's our law as citizens. That's my starting point. Of course, you're right, and it's an important point, that in any contemporary state, many of those who find themselves either victims or defendants are not citizens. So they're in various guises as tourists, as visitors, whatever, as long-term workers. And they need to be part of the picture. And one key category here is that of guest. If you're a guest somewhere, then that gives you have a distinctive normative status, which includes being protected and bound by the local laws. So if I assault Francois, then I'm tried, what gives you kind of jurisdiction is I'm here as a guest. And that's why I have to answer to you as well as to Francois. So I guess we'll do some work there for some kinds of case. In other cases, you might say, okay, some countries have a principle of nationality, so they will claim jurisdiction over crimes committed by their citizens anywhere in the world. And that fits very happily with my account, because if you're a citizen, then you answer to us what you do, even if you do it somewhere else. Likewise, you might say, we might claim jurisdiction over what happens to our citizens elsewhere. If I'm attacked in Canada by Francois, then maybe a British court would insist on trying Francois to get hold of him. So you can do that kind of work. Then you get to other cases, like the ones you mentioned, of piracy and military law and so on. There, you're dealing often with wrongdoing which doesn't fit within this kind of national political boundaries anyway. Piracy is treated on the high seas, as it were, against anyone at all. And then you need a different story about what's going on here, which also goes along with other kinds of international crime, which don't have a particular national limit to them. So I agree, there's no simple story. But I do think it matters, though. It always matters to ask, in whose name is this court acting? By what authority? And the authority must depend upon some community whose law it is applying. And the case of warfare is different again, because, and again more complicated. As I said, if we're at war, then how is membership understood and of what? So I agree, there are all these further complicated cases which I need to discuss. But I still think it matters, though, that we ask, well, under what description is this person being tried? Is he as citizen, as guest, as what? And by what authority? And the authority itself must then depend upon some political community whose law is being enforced. So yes, you're right, there's lots more to be said, but I think I can see ways of starting to say it.
Thanks very much for that, Anthony. It was, I enjoyed it quite a bit. I do have a question, though, about the starting point. So you're theorizing about the trial, and it's a compelling account, I must confess. I've gone along with you. But I guess there's this important contingency. And for me, I think about the investigative process quite a bit. And so the people that come in and how they come into the trial process, that matters a great deal. And I wonder whether the goals that are served by your account of the trial process are attainable without an account that addresses the investigative process too. So if there's selective enforcement, and that can happen, or discriminatory enforcement, and that can happen at the domestic or international level, does that undermine the realization of the goals? Does it delegitimize the trial process itself? And I can give many examples, but I don't think I need to. I think they're somewhat obvious. So that's the question.
And the quick answer is yes, you're right. In two ways. First of all, you're right. Of course, the theory of the trial can't stop there. Stage two would be a theory of the criminal process going before the trial. And give us the money, we'll do that on our next project. No, you're right. The theory says that we need to go look before the trial to what goes on with the police and what goes on with prosecutors before you get to trial. That's obviously an important thing. And if the culmination of the trial, as I portray it, that had implications for what must go on earlier to lead towards that process. That's one point. And secondly, you're right, that if the process which precedes the trial is discriminatory, arbitrary, unjust in various ways, that then undercuts the legitimacy of the trial. Because the trial says, look, we call you to account as a citizen to us as your fellows. So the trial insists on treating the defendant as a citizen who's a fellow of all of us. One result could be, but look at how else you've treated me. You've not treated me hitherto as a citizen. You've treated me in various ways unjustly. I suffered this and that kind of disadvantage, including at the hands of the police. How dare you now treat me as if I answer to you? Because my treatment at your hands, your collective hands, undercuts your right to call me to account now. So the trial, as this kind of process according to account, depends upon preconditions of justice, which are often not fulfilled. And I think it's a merit of the account that brings out that point. They seem to be genuine preconditions of a just criminal process. And you see why they're just, because if we demand the right to call you to account, then we also need to account to you how we treated you. So I'm right, that's another important dimension. So various kinds of radical failing in the criminal process that make the trial illegitimate, even if the person is provably guilty. Yeah, perhaps this is the key point. Maybe you can prove beyond any reasonable doubt this person did it. You've got the evidence there, you've got all the stuff you need. There's no way he's not guilty. But still, you can't put him on trial because the trial itself, as a process of calling to account, is illegitimate if we don't have the right to call into account. And that needs to be crucial.
Thanks, Anthony.
Good afternoon, Dr. Duff. Good afternoon, everyone. I had a follow-up to the professor's question. It's in the nature of that, but I wanted to ask about in terms of the selection process as well, because countries like the United States, Israel, China, for example, they're not declaring war per se, and I'm wondering about the standard by which the International Criminal Court measures in terms of initiation for action, because you had said earlier that if a particular state is unwilling or unable to facilitate a trial or pursue that, then the ICC steps in. However, what about countries that are taking actions that are in violation of the outlined Human Rights Code or its crimes against humanity? Israel, the vis-a-vis the Palestinian conflict, the United States with bombing in Pakistan and civilians are being killed, and it's being termed a collateral damage. I recall Donald Trump once saying they're redefining what victory is or what in terms of the parameters of war is. And the danger I'm wondering for the ICC is not only the processes becoming invalidated, but that authority, that moral authority that it has, is totally being extirpated. And when you talk about complicity of nations, it's the court itself in lieu with the United States and Israel, China, and those countries, like what happened with the Khmer Rouge, if that silence is not a deafening indictment in and of itself. So, yeah. Yeah,
thank you. And yes, you're clearly right that supposing this is the case, supposing that you have an ICC case where the case taken by itself is absolutely as it should be. The defendant's called to account, they're given a chance to defend themselves, their guilt is proved, everything within the case is as it should be. Do we say, right, justice is done? No, we can't say that. We need to ask about the wider context in which this particular case happens, about the ICC's general conduct towards the kinds of crime which fall within its remit, and how far the investigations which get cases to the ICC are themselves just processes. So that the legitimacy of an individual case depends upon it being part of a system which itself is just. So if it's the case, so then this is the worry about any such crime. We go back to Nuremberg and on through the ICC, that we're dealing here, if not with victor's justice, then with justice asserted by particular powerful bodies against others who are weaker. So the justice is not being done impartially. So we ask what cases get recognised as cases of the ICC, which get selected, how they get there. We're not dealing here with anything like a just system of enforcement. The selection is not based on appropriate rational criteria. Insofar as that's true, that undermines the authority of the ICC to try even the cases it does try, even when there's a genuine wrongdoer, because again, the court's authority depends upon it being part of a system which itself can claim to be just. And this is a real problem, I think, for the ICC, that on the one hand, there are cases which it deals with which are themselves cases of serious wrongdoing which cry out for justice. But at the same time, by being part of a system which doesn't deal fairly with all the range of cases it could deal with, that undermines the court's authority. So yes, you're right, this is one problem for international justice, that it needs to be international justice rather than partial justice. And the ICC is a long way from achieving that.
Otto Phillips.
Hi, Otto Phillips, Osgood. Basically, I just wanted to get you to talk a little bit about an assumption I think is underlying all of this, which is fundamentally a commitment to democracy that's going to make sense of the criminal trial. So when you talk about citizenship, the idea is that we have an equality amongst all the citizens within our community, that we need to justify our actions to our fellow citizens who are on equal playing fields with us. We've taken advantage of something, and this is usually the technical way of putting it, where you've taken advantage of something that somebody else hasn't had. The question I have is, when you look at the international community, not all the states are going to be democratic. And so does that then mean that the criminal trial takes on a different meaning in those states that are not in fact democratic? And then further, how do you apply that when you end up taking these non-democratic states to account as a place like the ICC, when the relationship among citizens within that state just doesn't seem to fit the model?
You're right. In the case of domestic criminal law, I presuppose, I take for granted, a rough notion of liberal democracy as being the background within which the trial happens. And that citizenship, as you say, is equal citizenship in democracy. One question then is, okay, what form could criminal trials take normatively in non-democratic countries? To whom then are defendants called to answer? Is there any room for any idea there? Any room for the idea there? They're answering to their fellows, and who are those fellows? So, imagine societies. Well, think of societies with various kinds of hierarchy, with inequality, or think of monarchies. The question is still, okay, to whom and under what guise do you answer? And easily recognise you. And I suppose one question answer would be, well, sometimes you answer to the monarch for violating his edicts. That's the old-fashioned view. That's the right of kings. Or in other kinds of hierarchy, you might find that in terms of local understandings, inferiors answer to superiors, but not vice versa. So I don't answer to you if you're my inferior. Of course I don't answer you. What right do you have to come to account? So you're right. So in all kinds of ways, you'd find in undemocratic societies, they might be calling to account, but not to your fellow citizens, but to some other more hierarchical group. That's clearly true when they argue about democracy with those people. So then the ICC comes in, speaking for the community of nations, or so it wishes, many of which are not in their own domestic arrangements, democratic or egalitarian. And so then, okay, let's try and get this more concrete. So we're dealing with such a case where within a particular undemocratic nation, these crimes are committed. They fit the definition of the crimes against humanity. And the ICC then claims the right to try the case because the local state didn't. And your worry is, which is not my worry, that I can't explain how the ICC could have standing here because if I say the ICC is still calling the wrongdoers to account in the name of their fellow citizens, to whom they should be answering, but then that doesn't fit the reality of the state within which the crimes are. Am I getting your worry? Yes, I'm now worried about that. That's a real problem, which is part of a larger problem, I suppose, which also ties back, I think, to your question. The ICC asserts a certain image, picture of the law. And we agree that certain kinds of procedure too, through which law will be enacted. How far can those claim to be universal? Or how far is the ICC part of the process of imposing a picture of law on others? And a further twist to that, which again ties in with your question. I said blithely, the ICC speaks on behalf of the victims of these crimes, who has let them down. Well, it doesn't actually consult those victims, typically, saying, are you willing for us to act? It will insist on trying the case, whatever they might hear. So again, it seems an odd kind of on behalf of when you don't actually speak at the request of the victims. So it looks like the danger here is then that there's kind of putting up benevolent paternalism or oppression going on. The ICC is insisting on imposing a certain section of law and also what goes with the law in terms of democracy on contexts where it doesn't in fact fit. So either the ICC must say, look, in that case, we're powerless. Or we say, look, like it or not, we're going to treat it as if you were a democracy. And that's a further genuine worry. I think in the end, I'm going to have to bite the bullet and say, well, the ICC, the system of international criminal law is to that degree going to be paternalistic. And it's just like, we're going to make the person answer on your behalf, even if you don't recognize yourself. But that's already worrying. I'm just not sure what to say. As you can tell, I'm gabbling around. But this is part of the larger issue about the authority of international criminal law. I think the general point then is this, not the general point. It seems to me it has to be true that any system of criminal law has authority only as part of a political structure. And that seems to me has got to be right. If so, then we can't detach criminal law too far from particular kinds of political law. Well, we need to ask then what kind of political structure makes room for criminal law, and how far can we get a criminal law which can be shared by those of quite different kinds of political structure, shared by democracies with non-democracies. And I'm not sure how far we can. On the other hand, the generalist interpretation is that criminal law requires some notion of wrongs which concern the whole polity. How the polity is understood, whether the polity is understood as democracy or as a monarchy or as what. The trial calls the person to account to that political community, where the two might be to the citizens or to the monarch or to some hierarchical notion of whom they answer to. So you have the same formal structure fitting quite different political structures, the same formal process according to account. But then the worry is this, I suppose, this is going to be worth pushing your point a bit further. Think of the kinds of crime against humanity committed within a particular polity against groups who are already politically seen as inferior, as subordinate, as state not equals. Maybe not quite groups who are seen as, well, that's what they deserve, but at least groups who don't have the standing of equal citizens. If the ICC takes on that kind of case, and if the refusal to pursue it locally reflected not just some failure by the state apparatus, but a failure by as we see it, by their fellows to treat them and take them seriously as citizens, then the ICC is certainly in that case imposing from without a conception of equality which it is not locally shared. And that's one kind of humanitarian intervention which is going to cause problems. So And the issue for me then is not so much whether that can be justified, but whether it can fit with my kind of picture, which is grounded in some notion of political community. Or whether here I say, look, communities can't do the work anymore. I need to think about that.
One quick last question, Dr. Amatrudo.
Okay, truth did a lot of work in your paper. At one point, you mentioned truth a lot. But I think truth is sometimes a very provisional kind of concept. Two examples, not from the Nuremberg trials, but from the Einsatzgruppen trial, and the kind of defence sort of im Sinn der Anklage nicht schuldig, in terms of the accusation not guilty, it wasn't a crime then. And in terms of the Einsatzgruppen trial, the way the court put to one side issues of membership of Sicherheitsdienst, SS and stuff like that, which were corporate crimes. They didn't pursue those at all. They only pursued the crimes against humanity as a collection of nations. So that's one. The other one is alive in the courts at the moment, which is property ownership in former Warsaw Pact countries. I'm thinking particularly of Hungary and Poland, and the issue of ownership of property. What country, when did you own this? What political situation gave rise to that ownership? So there is a truth somewhere, but I think sometimes this truth plays itself out in these kind of ways, these little issues of temporality in history. And I'd just like you to just say something about that. Judging the past by the present.
Well, and there are different issues here. Well, okay, the issue about it wasn't a crime then. I see it being to a degree separate from my concerns here. It's an issue for any account of law, how far the law can be made retrospectively in that way. How far you appeal to some notion of natural law to justify, say, it wasn't really a crime, even if the law didn't declare it as such. I guess I think all I need to say at this point, as a placeholder for further investigation, is that for a criminal trial to be possible, this relates back to a previous point, for a criminal trial to be possible, there must be a determinate law in place which the court can claim to be interpreting and applying for this instant case. Let's say that the kind of truth that a criminal trial can get towards is a very limited truth, that the person is or is not guilty of this offence as defined in the law. There's bound to be room around the edges for the court to be interpreting the law in applying to a new case, but it must have to rely on some fairly solid notion of what the law is. So we're dealing with it wasn't a crime then defence, or dealing with, well, in the property case, what do you imagine? Imagining a trial for theft, or for, what do you imagine in the criminal case here?
Yes, I mean, we own this. When did you own it? Under what purpose? Under what system did you own it? Is this valid now? Take Hungary. It's been 6 or 7 countries in the last 100 years.
And that sounds to be a dubious context for a criminal case. The dispute about ownership sounds more like the kind of civil case where you argue back and forth about who has the strongest claim to this property between various competing parties.
The sets of cases I'm thinking about are where the property ownership itself is a matter of like a criminal concern. For example, during the time of the Nazi period, property was given, legally titled property was given away. Now, what do we do about those claims for it? But the ownership itself may be criminal.
In what way? Sorry, I'm trying to say where ownership is genuinely in doubt, then there's not room for a criminal case yet. And ownership should be settled through the civil courts, if it's settled at all. We have to have places to argue back and forth between people with competing claims. That sounds evasive, I expect, but that's my best shot off the cuff.
Okay, on this note, I'd ask you to join me in thanking Professor Duff for what was a really thought-provoking presentation. We have some token of appreciation. That's the poster in which we made you up as a superhero.
Right.
And some little Osgood paraphernalia for you to remember
nice.
with fondness your trip to Osgood and the Nathanson Centre. Thank you very much.
Well, thank you all very much.
Thank you all for attending.